Here are some things you may not know about child sex offenses in Texas. Child sex offenses don't get discussed much, and that is probably understandable. But here's some things that you should know, particularly if you're a young adult, you're dating, or you're sending your kid off to college, or your child is entering the dating scene. First and foremost, it does not matter what the other person tells you their age is. If they're a minor, and for most purposes, when we say minor in the state of Texas for child sex offenses, we're talking about someone who has not yet reached the age of 17. If they're a minor and you engage in sexual contact with them, that's going to be a criminal offense. In fact, if you engage in a conversation that alludes to meeting for a sexual purpose or a conversation that is sexually explicit, those are also ways to end up committing a crime. Notice in these offenses, if the person didn't actually know that the minor was in fact a minor, they didn't intend on committing a crime. And yet the law doesn't make that distinction. It treats it as if this were a strict liability offense. It doesn't matter if the minor represents that they are an adult. That can be verbally, that can be by getting on a website or a dating app that is meant for individuals 18 or older, or even meeting you at a place where you expect only 18 and up individuals to be, or 21 and up, like a bar or an establishment that serves alcohol. None of that is going to be a sufficient legal defense. Now, it might be mitigating. In other words, a prosecutor might take it into consideration in determining what the appropriate outcome should be, but it will not save you from being arrested. It will not save you from having a criminal case filed against you. And sometimes it's not even going to be enough to avoid a conviction or registration as a sex offender. This is a serious matter, and you need to be aware that this is treated as a strict liability offense. And if you have kids going off to college, they need to know that as well. That leads us right into the Romeo Juliet statute. You might be thinking, if you're close in age to the person who is a minor, is there a defense? Sometimes referred to as the Romeo Juliet Law. There is, in fact, an affirmative defense that applies to people who are close in age. However, it is not always a 3-year Romeo and Juliet statute, as many people, even attorneys, commonly think. In Texas, the Romeo Juliet statute is an affirmative defense. That means if you are arrested and prosecuted for a child sex offense, you can raise this affirmatively as a defense. Notice this does not avoid the arrest, the criminal case getting filed. It is simply something that can be raised in court as a defense. If this defense applies to you, it means you're not going to be held criminally responsible for engaging in sexual contact with a minor. But as I said, it's not always a 3-year exception. The reason most people think that it is a 3-year rule is that for sexual assault itself, there is a 3-year Romeo Juliet statute. That means if you're within 3 years of the minor, and the minor is at least 14 years of age, then there is an affirmative defense that you can use to avoid things like a conviction, time in prison, and registration as a sex offender. The Romeo Juliet statute for online solicitation of a minor and indecency with a minor is also 3 years. However, for the offense of sexual performance by a child, the Romeo Juliet statute is only 2 years. And for the offense of continuous sexual assault of a minor, the Romeo Juliet statute is 5 years. The Romeo Juliet statute for electronic transmission of certain visual materials, essentially sexting, is 2 years. We talked about the fact that generally in Texas, 17 is the age at which a person is no longer considered a minor. However, it's important to understand that federal laws might also apply to certain types of conduct. For example, if a person crosses state lines for the purposes of engaging in a sexual relationship, then it can become a federal offense. If the person is under the age of 18, then they're considered a minor in the eyes of federal law enforcement agents. So you can commit a federal offense by crossing state lines and engaging in sexual contact with someone who might otherwise be considered to be an adult in Texas. That's a 17-year-old, because under federal law, they have to be 18 to be considered an adult. While most people don't like talking about child sex offenses, it's important to educate yourself, your friends, and your family members about these offenses, particularly once you understand that these offenses can happen without the person who's being accused intending for it to be a criminal offense or intending to have a relationship or sexual contact with a minor. If you've been charged with a sexual offense in North Texas, give us a call. We have represented individuals charged with every level of sexual assault offense, from child accusations through adult accusations, and we've defended them successfully. You can find out more at versestexas.com or call us at 817-203-2220. We made this video in response to a question we received on this channel. If you have a question about criminal law in Texas or federal criminal law, drop a comment below. We'll be sure to answer it in a future video.